रेडी। एक वर्ड होता है एक्स पार्टी। एक्स पार्टी, EXPARTE। on one side, ex officio, EXOFFICIO, by virtue of his office, by virtue of his office, ex officio, ex gratia, EXGRATIA, as an act of grace, ex gratia, ex post facto, ex post facto, retrospective, in absentia, in absentia मतलब in absence, faith, F को ऑफ कर दिया, ठीक, faith, accompli, FAIT, fate, fate के साथ में ACCOMPLI, accompli, a thing already done, fate, accompli, a thing, FAIT, TH नहीं है, only T तक, fate, accompli, a thing already done, in absentia, in absence, ex gratia, as an act of grace, ex post facto, retrospective, ex officio, by virtue of his office, ex parte, on one side। डिक्टेशन लिखेंगे, रेडी, स्टार्ट इट। While making any correction in the entires relating to these matters, the requirement of moving the application within 3 years has to be adhered to, as any correction in regard to these entries would have an impact on the rights of other candidates when they seek admission to higher classes or employment. However, the other particulars contained in the certificate, like the name of the candidate or the names of the parents of the candidate, are not that relevant, and any correction made in regard to these particulars would have no impact on the admission or employment of other candidates. When so considered, we feel persuaded to hold that the time limit of 3 years prescribed in the substantive part of Regulation 7 for submission of an application for making correction in the certificate issued by the board in regard to the name of the candidates or the names of the parents of the candidate should not have been insisted upon, particularly when the board itself considered it appropriate or the names of the parents of the candidate to have no time limit under the proviso for making correction in regard to any spelling mistake in the name of the candidate or his parents. The applicant must, however, explain to the board the reasons on the basis of which the application could not be submitted earlier, and if it is found that the claim is bona fide and is otherwise justified, there is no reason to reject the application as in the present case merely on the ground of delay. Undoubtedly, the board has to examine whether any genuine ground has been made out for correcting the name, and it would be open to the board to consider all the relevant materials pertaining to the request for correction of the name. In the circumstances, we are of the view that the impugned order of the first respondent rejecting the application submitted by the appellant for correction for the name of his mother in the high school and intermediate examinations only on the ground of delay is unsustainable. We accordingly direct the first respondent to reconsider the application, having due regard to all the documentary evidence which may be produced by the applicant. The first respondent would also be at liberty to summon all the relevant records from the concerned institution for the purpose of deciding the application of the appellant. We clarify that the interpretation which we have placed in the aforesaid terms governs only the mistake in the certificate in the name of the candidate in the names of his parents. The first respondent shall now pass a fresh order in accordance with law within a period of 4 months from the date of receipt of a certified copy of this order. In order to facilitate this exercise, the impugned order dated 11 October 2013 is set aside. The order of the learned single judge shall in consequence be set aside and be substituted by the aforesaid directions. The appeal is accordingly allowed to the extent indicated above. ये 500 वर्डों के साथ डिक्टेट किए गए। क्रिमिनल मैटर का 11 नंबर है और स्पीड 80 और फ्लक्चुएशन 4 या 5 वर्ड अपसाइड में है। सीपी लीगल से लिखेंगे। रेडी? Start it. The proviso to section 6A of the Hindu Minority Guardianship Act states, provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother, which is prima facie arbitrary and does not fulfill the criteria laid down for reasonable classification. Thus, it violates Articles 14 of the Constitution. Articles 14 outlaws discrimination in a general way and guarantees equality before law to all persons and is expressive of decissory of the rule of law. Article 14 also affords to all equal protection of laws. This denotes equality of treatment in equal circumstances. It implies that among equals, the law should be equal and equally administered, that the like should be treated alike without distinction of race, religion, social status, etc. Thus, it means the right to equal treatment in similar circumstances, both in terms of privileges conferred and liabilities imposed by the laws. There should be no discrimination between one person and another if, as regards the subject matter of the legislation, their position is the same or substantially similar. There can be no doubt that in the early stages, mother is the support that all children need, but in case of a male child, close sustained exposure to the respected male significant other is necessary, since it is through this exposure that the child imbibes his first ideas of gender based social function. It is now an established fact that there is no preferential need in general, but an equal need for both parents for the proper development of the child. There is nothing in the realm of contemporary scientific data to support the presumption underlying the proviso to Section 6A. Furthermore, it has never been held to be detrimental to the child's physical and psychological welfare to be committed to the sole custody of the father. On the contrary, it is at this crucial juncture that the presence of the father becomes indispensable. If nature has ordained the role of the mother to be indispensable to the child in certain regards, then it has certainly not ignored the father. The assumption that a mother's full-time love is needed for the proper care of children is not in conformity with the facts of contemporary society. Moreover, they said proviso is subject to the disqualification under Article 15(1) of the Constitution and is not saved by Article 15(3) of the same. Discrimination as used in Article 15.1 implies an element of unfavorable bias. Article 15.3 postulates a situation for the benefit of women to remove the fetters of centuries of subservience and bring them at par with their male counterparts. Article 15.3 is applied when the woman is apparently not at par with the man. Applying Article 15.3 in today's scenario would undermine a woman's worth by treating her as an unequal. In the existing social scenario concerning child custody, however, the judicial precedent expressly condones preferential treatment in granting the mother custody of the child. There exist catenas of decision wherein the courts have sympathized with the mother and in support of a fictitious biological need have always granted custody to the mother. In the contemporary scenario, it is the man who requires protection under this clause who has been denied equality in a substantially vast majority of cases. Further, the first part of Section 6 of the Act appointing the father as the natural guardian has been whittled down by judicial decision to such extent that is now disregarded as being mandatory, thereby resulting in the same almost never being applied in practice. ये 597 वर्ड डिक्टेट किए गए हैं और 80 की स्पीड है, फ्लक्चुएशन ना के बराबर है। 3P लीगल का 11 नंबर मैंने आपको डिक्टेट किया है फिलहाल। ये दोनों चीज़ें आपको सॉफ्टवेयर मिल जाएगी, टाइप कर सकते हो आप। इसके बाद मैं स्पीकर पर लगा रहा हूँ ये कंटेंट।